Welcome to the ARC Greater Twin Cities presentation on the top 8 things to consider when starting guardianship. This presentation is given by the ARC of the Greater Twin Cities. We're located in St. Paul, Minnesota. This presentation is based on our knowledge of the Minnesota legislature, the court systems, and its workings. The ARC Greater Twin Cities mission is to promote and protect the human rights of people with intellectual and developmental disabilities, actively supporting them and their families in a lifetime of full inclusion and participation in their communities. The ARC Greater Twin Cities was started over 65 years ago from parents and caregivers of children with disabilities. They wanted more for their children and they wanted more in the community, so they worked together through grassroots actions to create services and supports for their children in the communities. The ARC is still doing this today. We work really hard to make sure that services are available for people with disabilities and families know how to access them. This presentation covers the top 8 things to consider when starting guardianship. This is a brief presentation, really only highlights on the overall guardianship process. This is a wonderful way to start considering guardianship and if it will work for your family. This is by no means meant to be a comprehensive overview. Again, it's just a brief presentation touching on the top 8 things to consider when starting the process. For more info, we have many presentations in the community. You are more than welcome to attend one of those. You can also call the ARC Greater Twin Cities at any time, or you can speak directly with a guardianship lawyer. Guardianship is a substitute decision-making process. This is our first point that we want to make. When an individual turns 18 years old, they are legally considered to be their own adult, whether or not they have a disability. This makes substitute decision-making a very important process for many people with disabilities that can't make decisions fully on their own, that may need support. Substitute decision-making can come in 2 forms. It can be a formal process, which is guardianship, or it can be an informal process, which includes less restrictive alternatives. In the end, it's most important to consider the person as an individual and to consider what this individual needs. Independence is always valued, and we want to make sure that families are considering all of their options that they have. The role of the guardian is to ensure the health, safety, and welfare of the person that they are guardian of, or the ward. The ward is a term that is used throughout the legal guardianship process. A ward is a person who's under guardianship. This is a legal term that you will hear the attorneys and court systems using. You'll also hear it in this presentation. So a ward or a protected person is somebody who's under guardianship. It's important for a guardian to consider the health, safety, and welfare of the potential ward. That's their main role, but it's also very important for the guardian to consider what the person wants. So what their dreams, what their hopes, what their desires are, because this person still has a life that they want to live, and it's important that the guardian respects that and helps them accomplish those goals. That's really what guardianship is. It's really all about helping an individual meet their goals and their wishes for life while making sure that they are healthy and safe and they have good support set up for them. Guardianship is not what we like to say a my way or the highway situation. It's really about working together to make sure that this person has everything that they need to accomplish what they want to in life. A great video that explains this is the Guardianship and Conservatorship video created by Hennepin County. This video was created by Hennepin County to help explain what guardianship and conservatorship is to families. This video can be found at www.mncourts.gov. You go to the Help Topics, which is on the upper left-hand corner, and then you click on Guardianship and Conservatorship. And then once you're on this page, you'll see that there's a video right there at the bottom. Again, this video has a really wonderful explanation of what guardianship is and what guardianship is not. And it is also required to be viewed by many counties in the metro area. Less restrictive alternatives should always be considered when thinking about guardianship. These can be any of the things that are mentioned here on the slide, and they're all things that should be considered for a person individually. So you're going to want to think about the areas in which your loved one needs support and then how maybe you can use less restrictive alternatives instead of guardianship, because guardianship is a legal process where it does take away somebody's rights to make decisions. And so it's important whenever possible to give a person as many rights throughout the process. So informal supervision, joint bank accounts, healthcare directives, a living will, a power of attorney, and a representative payee are some of the things that people have done in the past that we've seen. All of these, like I said before, enable some retention of rights while still getting the support that they need. And these are the guardianship powers. So there are 7 guardianship powers, and when you're thinking about what your loved one needs assistance with, think about it in these 7 different areas. So guardianship is broken down into these 7 parts. You can take all of these areas of guardianship, which would be full guardianship, or you can pick and choose the areas that your loved one needs assistance. So you could say, my loved one only needs assistance making medical decisions and accessing government benefits. Other than that, they really have a really great solid foundation of making their own decision in the other areas. So it's really up to you to have that conversation with your loved one on where they feel they need assistance, where you feel that you can help them, and where you feel maybe you can use less restrictive alternatives in other areas. So going through the different guardianship powers, the first one is determine place of abode, so their residence. So this would be where they live. So this would be helping them determine, if a bus line nearby is really important, maybe let's find an apartment or a home that's really close to a bus line so that they can get to work, things like that. Number 2, care, comfort, and maintenance. This would be need for shelter, nutrition, access to services, including academic and vocational services. So when we're talking with families, number 2 would allow a guardian to still sit in on IEP meetings, to be able to have meetings with vocational providers to help determine future for getting services around jobs. Number 3, reasonable care for personal effects, clothing and furniture. So this is making sure that an individual has proper clothing and furniture, making sure that that all of this is safe and in good care for them. Number 4, medical and other professional care. So this doesn't mean that you have to attend every single doctor appointment that your loved one goes to, but it is helping them make decisions on big medical concerns and parts of their life. So helping them determine, if a certain medication is good for them, or if they want to go to, or if they should be going to physical therapy once a week, things like that. Number 5, approval or withholding of legal contracts. So this is when you're able to help your loved one make the decision about a legal contract that they're signing. So this would be a lease on a car, or a lease on an apartment, or a credit card, or anything like that, anything that's bound by a legal contract. This would help you help your loved one make those decisions. Number 6, supervisory authority. So this is who an individual spends time with out in the community. Guardianship is one of those things where guardianship is not going to protect your loved one from making mistakes. There's still going to be those things that can happen, but guardianship is set up so that you can help your loved one make decisions in their life. And number 7, accessing government benefits. This would be help applying or keeping government benefits such as Social Security or medical assistance. This can be a really important one for families. Think about if your loved one were to have a piece of mail from Social Security come in, would they be able to open that piece of mail and know what to do moving forward then? This may be an area, again, that you would maybe want to help them with. Guardianship does require court approval. The court bases the appointment of guardianship on clear and convincing evidence of incapacity. So when you're considering the 7 areas of guardianship and how your loved one needs assistance in making decisions, consider how you can present that information to the court in a clear and convincing way, because this information that you gather will be put into a petition, and this petition will be then given to a judge. The judge will look it over and will say yes or no as to this person needing guardianship. So you're going to want to make sure when you enter this process that you have everything that you need to tell the court why your loved one needs assistance in making decisions. Because of this process being a legal process, we do highly recommend that every family going through it works with an attorney. If you need assistance in deciding which attorney to work with, we have a pool of attorneys here that work in the areas of guardianship. If you would like to see this pool, or if you have any questions on this pool, we recommend that you call the ARC. This pool of guardianship lawyers is about 3 pages long, of attorneys that work all throughout the state of Minnesota and all throughout the metro area. So please, again, call us if you would like to see this list. Also, do not be intimidated by this being a court approval process. It is a legal process, but your attorney will be able to walk you through every step of the way. They know exactly what they're doing. They know the process. They've done it many times with many other families. So it can be an intimidating process, but rest assured knowing that your attorney and the ARC have been through it many times assisting families. So we're more than happy to answer any of your questions. It is very important to remember that civil and constitutional rights are retained under guardianship. So an individual still has rights even though guardianship has taken place. And this is a very important conversation to have with your loved one when talking about guardianship and what it will mean in the future. So having very open conversations is important about what guardianship is. It's a way for us to help make decisions like we have in the past. And what guardianship is not. That's also important to talk about. You know, this process isn't going to be me making all your decisions. It's not going to be me taking your rights away. We're still going to work together to make sure that you have all the support that you need. Again, it's just very important that you have this conversation with your loved ones before pursuing guardianship, because your loved one will have to go to court and they will be read the petition, so they'll know what's going on. And so it's important to have open, clear communication whenever possible. Within the Minnesota Statute Bill of Rights, there's also a portion that talks about the rights retained. And the ARC is more than happy to share this with you. It's on the Minnesota court legislature's website, and it covers everything from the right to personal privacy, to the right to marry and procreate, to the right to be treated with dignity and respect. So all of these rights, plus many more, are still retained under guardianship, which is another important conversation to have. Many families are concerned about the cost of guardianship because there are lawyers and a court process that is required. One of the possibilities for assistance with the financial piece of guardianship is in forma pauperis, or IFP, as we call it. In forma pauperis is an old Latin term that means in form of the pauper. What IFP is it's a way for you to have the guardianship process done for little to no cost. So IFP is based on the potential ward's income and assets. So if your loved one has little to no income or assets, you can ask the attorney to help you file for IFP. If the court deems your loved one as having very low income, so little to no assets, then they will waive the court fees and they will pay the attorney to help you through the process. This can be a really great asset for many families, and so we encourage whenever possible that people pursue this as an option. Another option for pay, of course, is private pay. If you're looking for an attorney that works with IFP, you can refer to our list, our pool of guardianship lawyers. We have, again, about a 3-page document on lawyers who work in the metro area, and each lawyer is designated whether yes or no they work with IFP. Ongoing responsibilities are very important to consider when thinking about guardianship. There is the annual statement of well-being. This, again, is a very important document. There are no reminders sent to you that you must fill this out, but you must complete it and send it to the county in which guardianship was established within 30 days of the annual time of when guardianship was completed. So if you do guardianship in April, that means every April you have to send in the annual statement of well-being telling the court how things have been going. So the court really wants to make sure that guardianship is still necessary, that you're still assisting the person that you're guardian over. They want to make sure that they're keeping tabs on everybody who they've approved guardianship for. This annual statement of well-being is about 3 pages, It's pretty straightforward. If you need assistance filling it out, the ARC is more than happy to help you, and oftentimes attorneys are happy to answer any questions that you have on this. Again, it's only 3 pages. It's pretty straightforward. The court just really wants to know how your loved one has been doing over the past year and how you've been assisting them. Within that annual statement of well-being, there is the right to petition. And this right to petition is given to the potential or the ward every year. And this right to petition informs the ward that if anything has changed under guardianship, if they would like to regain any more of their rights, if they would like to reestablish any of the powers of guardianship that they have, if they would like to change their guardian, the right to petition informs them that they are able to do that at any time. So let's say that your son or daughter is turning 18, and right now they need full guardianship, they need assistance with everything. But in 5 to 10 years, you believe and you want to have the possibility of changing that. You can definitely do that at any time. So right now you may have full guardianship, but in 10 to 15 years, that may change. And so you can go to court and you can have that reestablished. So these are the top 8 things that we recommend that families consider when thinking about guardianship. Again, this is not a comprehensive overview of what guardianship is and all of its parts. If you would like more information, please call us at the ARC Greater Twin Cities. We are more than happy to help and answer any of your questions. You can call us or email us at any time. Remember to call us for our pool of attorneys for guardianship. We are more than happy to give this to anybody. Thank you again for watching this presentation on the top 8 things to consider in guardianship, and call or reach out with any and all questions.